May I, my lord? My lord, item number 5, my lord.
Hmm.
Here, my lord, I'm on behalf of Mr. T. Tara, my lord. This matter may be adjourned for 2 weeks, my lord.
2 weeks. Huh? Petitioner, 2 weeks. Yes.
My lord, and item number 6 also. Same order.
Item number 6.
Same order
Okay.
for 2 weeks. Much obliged.
No, sir.
Please, Your Lordship. Well, this
Lordship,
Hmm.
Lordship, this legal aid counsel, Lordship, this advocate that madam, he's out of station. His letter of absence is there, Lordship. So it may be fixed another date, Lordship.
Weeks.
we have some
Lordship.
urgency in this
Obliged,
case.
Lordship.
Item 8.
Yes,
Yes,
well,
Mr. Das.
yes. Well, may it please, Your Lordship. Well, this PIL which we have filed.
Yes, there some issues are there. Will issue a notice.
Yes.
Before issuing
Okay.
any notice, if your lordship says in the last order, my lord, regarding the maintenance of this PL, my lord, the landlord council has to certify your lordship whether this is maintainable or not. Because other occasion also same crime was dismissed.
My lord, what I like to say, I am fully prepared with the
We'll
case.
keep the maintainability open.
Yes,
My
yes.
lord.
Let
So
notice. Your
today is the
Lordship.
next fix for that, my lord. Now he has to satisfy your lordship, my lord, regarding the maintenance.
Why?
This-
Why? First, we want to understand why this is not maintainable.
Yes.
Then only we'll ask him.
Then first, my lord, as per the High Court rules 2011, PL rules, my lord, they have not complied with. The second
What
is,
is that rule?
my lord, Rule 10, my lord, especially clause D, my lord, specific aberment, which are the class of people they will be affected, my lord, and why they cannot be approached this court. That, my lord, is not there.
Now, what is the case in this PIL?
The second issue is, my lord,
No. First let us address that issue.
my lord,
That they have not made any statement whom they are representing, and that those people cannot come on behalf of. Now, what is the subject matter here?
subject matter.
Yes.
Here, my lord, the allegation is, my lord, without executing the vote, there is saponing of money, my lord.
So
Yes.
who is the aggrieved person? All the citizens are aggrieved person.
The check, my lord, regarding that complainant's lodge, already SIC case is registered, charge sheet has been filed already, my lord. In this case,
That is one of the ground that it was not properly done.
my lord, not,
So first part is gone.
not properly
No,
ground,
no,
but
let us go one by one.
Right.
You are raising an issue of maintainability. Let us address this one by one. First is that no statement is made. This is not a representative PIL. So where's that statement is required? That will require only when it's a representative PIL. That some flood affected person, they cannot come to this court. Who are this person? Where is their villages? That can be important. Here is that misappropriation, allegation of misappropriation of the public fund, number one. Number two is that not proper investigation.
my lord. Then, my lord, if it is a misappropriation, definitely there will be a private party, my lord. The officers, who are the officers, my lord. Beside that also, my lord. this-
No PIL, no private party is required. Sorry.
My lord, beside
Somebody
it,
may be
but
affected.
beside
One thing
it,
I'd like to-
that also, if your lordship see
Your lordship see-
108, my lord, the previous PL, my lord, same thing,
Who filed that PIL?
same person, my lord, same
Let us see.
person,
Let us see
108,
that can be ground. Let us see.
108, my lord. Empolo Mena, my lord.
My lord, in the
Same
earlier
petition.
PIL, if I may clarify it.
No,
The-
Mr. Das, we will get time to clarify. Somebody has raised an objection as to the maintainability.
Yes,
Let us hear him. What is the objection? Then we'll come back to you.
yes, I am fully prepared.
Please wait. Yes,
Yes.
yes.
The lordship got it, my lord. Then, my lord, relevant it, paragraph 13, my
Now
lord.
let us see whether the issue. So this was basically Dite Dime Miging from 1 to 19 kilometer Upper Siang district.
Yes, my lord.
Agency called Project Brahmok under border organization. Okay. Now what is the subject matter of present PIL?
Same, my lord.
Same road.
Same.
Okay.
And if
Now,
your lordship see, my lord, order, my lord, paragraph 13 and 14, my
no,
lord.
we'll see that because
Yes.
see, to have a similarity, we must understand, and we take some time to
My
understand.
lord, yes, I agree, my
It is
lord.
my difficulty. I take some time to
My lord.
understand. Okay, this is, now where is the earlier PIL petition? Okay, now what is the order?
Malot, operative order is Malot 116 Malot.
116.
Yes, Malot, para 13 Malot. Your Lordship may kindly have from 12 also Malot. This refers to vigilant case and other things. And paragraph 14 Malot,
Paragraph?
14 Malot, no liberty was granted to the present petitioner to approach again. However, it was given to the affected persons Malot. It is made
Okay.
clear that this order shall not be.
Okay,
passed.
now
Yes.
let us see what is the issue here in this present period. Now, what is the status of the vigilance case?
Malot, the charge sheet has been filed. Malot.
Sarsiles in Pulse, yes. Mr. Das, let us take this matter this week or next week along with the disposed of PL. We want to
Yes.
see the pleading.
Yes.
Since an objection has been.
And in fact, Malad, one thing I'll have to counter his objection. Malad, the earlier litigation was for reassessment and resurvey.
We
of-
understand, we understand. The
And the
earlier case
liberty was
was that
given.
it was regarding payment of distribution of compensation.
But here
And
we
this
have
case
brought-
is basically fundamentally you are
Specifically.
saying that the investigation was not properly done.
Yes.
Fair investigation
Yes,
should be done
madam.
and there
Yes.
should be a fresh investigation.
Yes, and
This
the-
is your case.
Yes,
So let
and
us
the
have this
latest,
clear.
and the latest decisions of the Supreme Court are in my favor.
Then we can see, but there may be a agreement, that's it, that's why. Excuse me, because when we can release it, then and proceed with the plan. This is no problem with that. So let's let us see the finish. Okay, when? Give us a date.
Malad, can it be on the week commence? I'll be on out of station. Can it be on 22, Lordship?
Yes, when?
22 of August?
Okay, no problem.
Only one thing, since the respondent have themselves admitted, because PIL is not an adversarial litigation inquisitorial, the status report of the charge sheet that may be placed, my lord, because we are seeking a monitoring of the case. We are not seeking a investigation. We don't want to initiate because we know our
No,
limitation.
what will we monitor if the charge sheet is filed?
No, my lord, let them place the charge sheet if then at least
Then it will become.
clear. Because Supreme Court judgments are in my favor. For probity in public life, I have come. There cannot be any fetters on that powers. There's umpteen number of Supreme Court. I have given 3 judgments.
There is no requirement of any judgment on that
Yes.
point. Even if we think that your the subject is very important, it's having public importance, and you are a man who has been put by somebody, we can delete your name and proceed on our own.
Yes.
No
yes,
problem on that.
Yes, Lord, because the materials are there.
Law is clear. Before
Yes,
that,
sir.
no judgment is required.
Yes.
Yes. Uh,
Obliged.
Objection as regards maintainability of the present petition is raised by the State Council on the ground that similar issue was dealt with by a coordinate bench in PIL 7 of 2022, and the same was dismissed on 5/5/2022. First of, in view of the aforesaid, let the record of PIL 7/2022 within bracket since disposed of be tagged along with this petition and be listed on 22nd of August 2024. First of, the issue of maintainability shall be dealt on the said date as recorded in this court's order dated 26/7/2024. List accordingly.
Well, dismiss with liberty, that may be recorded. We were given the liberty to approve.
That will see, that record will say whatever we say.
Well, will they produce the charge
Yes.
sheet?
Yes. You be ready with the charge sheets to show that the no cause of action survives. That can be one of your ground. Keep the charge sheet ready. Yes.
Obliged.
Next. Yes.
On behalf of the victim.
Okay. No notice was issued in this appeal by this court under its order dated 9/5/2024. Appeal was not admitted. Full stop. This is an appeal against Swenson. Admit. Notice were issued and records were called for. Full stop. Records has already been received. Full stop. The private respondent number two. The respondent number 2 is also being duly represented by the learned counsel. Full stop. Accordingly, admit this appeal. This is an appeal under sponsors. Admit
Lordship,
as the parties are. Yes.
Lordship, I'm appearing on behalf of Zita Law. So
Oh.
we file an IA that may be taken up after a week.
Full stop. Full stop. In IA also issue notice returnable on give a date after 2 weeks. How much time will require?
Lordship, in next week only, Lordship. In IA also was same.
No, I'm not saying. IA, you need to file an objection, at least state. This is more than 10 years, or you don't want to file?
After 2 weeks then also.
Or 2 weeks, right? IA, 2 weeks notice, no formal notice will be required. In the meantime, parties may file objection.
File your Lordship.
Yes,
It's an appeal, Your Honor. Suspension of.
suspension only on the ground of health issue.
Okay.
So
That
health
was
issue,
taken
I
care
do
of.
not think now surviving
Lordship,
it.
that is
So
Lordship
that was taken care of.
taken care of, Lordship.
Huh?
That is already taken care of, Lordship.
Already taken care of.
Lordship.
Otherwise, no case of bail. We'll hear it,
Yes. Now, I'm ready for the hearing also.
not today. You cannot say that I am ready for hearing at 11:45, keeping everybody here.
Moreover, Lordship, the LSC Lordship, the council Lordship is on leave, Lordship.
Who?
Lordship,
Sure.
it's for victim party, Lordship, LSC. D Doji.
What to say? It is IA Likivo. The present IA was filed seeking suspension and grant of bail to the petitioner for his treatment.
Lordship. It's already taken care of.
It is submitted that pursuant to this court's earlier orders dated 6/6/2024, dated 30/5/2024, 6/6/2024, the petitioner's treatment has duly been done by the state authorities.
Yes.
Therefore, such cause do not survive
Lordship.
as on date. Full stop. Now, we'll close it. Peruse the materials as well as statement of the victim and other witnesses. Also peruse the impugned judgment. Full stop. After perusal of the same, this court is of the view that this is not a fit case for grant of suspension of sentence at this stage. Accordingly, IA stands closed. Full stop. Appeal is required. Any paper book is required?
book is ready.
Paper book is here.
Ready.
Ready.
Okay, paper book is ready. As the paper book is ready and matter is as the matter is ready as regards service as paper book. Full stop. Let this matter be fixed for hearing
On 10th of September,
on 19th.
19th of this month.
Yes.
Okay. On 19th.
Obliged.
We are ready, Your Lordship.
Yes, ready?
Yes, Your Honor.
Yes.
Yes, Your Honor. Your Lordship, I have gone through all the charge sheet and the deposition of the witnesses, Your Honor.
Take your breath. Have some water.
Uh, So, Your Honor, I don't find any ground for the appeal, Your Honor. Is my house
Hello, Court Master Ji. Court Master Sir. Court Master Sir. Court Master. Court Master Ji. Court Master Ji. Court Master Ji.
Yes, may I, Lordship, Lordship, I beg to mention the item number 3, Lordship. Item number 3, Lordship. Lordship, here I may be allowed to withdraw the petition as some vital documents has been missed, Lordship. You are Mr. B. Typodia. B. Typodia, Learned Counsel for the petitioner submits that there is some error. There is some defect in filing this petition as some vital documents are not annexed. Accordingly, he submits that he may be allowed to withdraw this present petition with a liberty to
Yes.
file a fresh petition. Prayer is allowed. Accordingly, this petition stands closed, dismissed on withdrawal with the liberty as prayed for. Obliged, Lord.
Lordship, I would like to mention item number 31, Your Lordship, on behalf of Senior Government Advocate S. Tapin. Lordship, he has some personal difficulties today, Your Lordship. May kindly take up this matter after a week.
31,
31.
okay, after a week,
Obliged.
after 2 weeks period. On behalf of the learned State Council.
Your Lordship, I beg to mention item number 8.
Item
leading-
number,
8.
yes,
The leading counsel, he is from Guwahati, and due to his personal difficulty, he is not able to appear today. So he-
affidavit file or not?
the opposite party hasn't filed. I'm for the petitioner.
Yes,
The
it's a
la-
contractor's bill, payment of bill.
Payment of. So
I'm not.
Who is,
I have informed the respondent.
wait for
he-
some time. We'll ask them to file the affidavit.
He has informed me that today he will be filing the affidavit.
He will file when?
Today he will be filing, he said.
Okay,
on
the
28th
the
of
present
August.
matters pertains to non-payment of contractors' bills. Accordingly, the learned counsel, accordingly, the state should file their affidavit whether such claim is admitted or not. Full stop. Full stop. List this matter after,
On 28th August.
huh?
On 28th
On
of August.
20 August
28.
28 August 2024. In the meantime, the respondent may file their affidavit. Yes,
May I, Your Lordship? Your Lordship, I beg to mention item number 7, Your Lordship.
item number 7.
Yes, the leading counsel, Mr. Estapin,
Uh-huh.
due to some personal difficulties, Your Lordship.
Of whom?
Correspondent 1 to 6, Your Lordship.
Respondent number 1 to 6. Yes, Devi.
I have no.
A prayer for affidavit is affidavit file.
Yes, affidavit.
Yes, Your Lordship. Fine.
It is submitted that the learned counsel representing respondent number 1 to 6 is having a personal difficulty today. Full stop. Accordingly, a prayer for adjournment is made. Prayer is not opposed. Full stop. Accordingly, same stance allowed. Please this matter.
Can you not that?
10th?
No, no.
Okay, 10th.
Obliged, Your Lordship.
10th of August.
Ma'am, Lordship, Lordship, I beg to mention item number 33, my Lordship.
33.
This matter is listed on 8th, day after tomorrow, my Lordship.
Why?
Mr. S. Tapin, he has some personal difficulties.
Item number
33.
33. Okay. Eight. On the prayer of the learned State Council.
Lordship, I beg to mention item number 5. On behalf of the petitioner, Orin Modi.
Yes, on why you want time affidavit file?
Yes, Lordship, we have filed. I'm for private respondent 3 to 12.
You have filed.
Yes.
And for the department, we have also filed.
You have also filed. Why you want time? You're senior. Okay, on the prayer of the learned counsel for the petitioner, matters stands adjourned and be listed after 2 weeks.
Lordship, kindly, it may be 3 weeks.
Why? You want to keep it on ventilator? 3 weeks.
And also Lordship, item number 24.
20?
Lordship, in this matter, I am representing respondent number 9.
No, it's a series matter. Item 21,
24.
24.
In this matter,
Wait for some. We'll after motion, we'll do the orders and finish it up. Yes.
obliged, Lord.
May my lord.
Yes.
I beg to mention item number 34 to 37
34.
to 39. My lord, the leading counsel is out of station. So this matter will fix up to 3 weeks.
Period will be over when?
Yes, my lord.
When the period will be over? This is an anti-defection, isn't it?
Yes.
They are still holding their post. There is a stay order. And stay is you have elected on 20. Anti-defection was on 2021. Now it will be over on 25. And he will come and say after a few days that this mission has become infructuous. Okay, you take adjournment, you are vacating the stay orders.
My lord, the leading counsel is out of station.
Who
So
is
that
leading
may be handled.
counsel?
K lawyer.
Huh?
K lawyer.
It is submitted that on the prayer of the learned counsel for the appellants. Reach this matter.
After 2 weeks.
Give the date, we'll post it after that. Give the date of your period that on which your period will be over. We'll fix it until 2026. After 2 weeks.
Much obliged.
This all whole will go 3, 34, 35, 36, 37.
Yes, this is same matter.
That is common order.
Right, please, Lordship.
Yes.
Lordship, I beg to mention item number 6 on behalf of K. Loner for the respondent number 8 and 9, Lordship.
Yes.
Lordship, both the parties are under forces for the settlement for outside the court. Lordship, we may
Who is outside the court?
both the party are under forces for the settlements, Lordship.
Okay. It is submitted that a talk of compromise is going on between the parties.
Lordship, I am for the respondent number 5, 6.
Do you have instruction any? Do you have any instruction?
No instruction, Your Honor.
He says no instruction.
Yes.
Then, okay, on the prayer of the learned counsel for the petitioner, matter stands adjourned for 2 weeks. Interim may be continued. He is objecting.
There is no instruction, Your Honor.
No instruction.
Yes.
Should you extend the interim order? Interim order pass earlier shall continue till the next date of listing. Yes.
Deeply obliged.
Lordship, I'd like to mention item number 9.
Item number 9.
Yes, I'm on behalf of L Perme for respondent number 5 and 6.
Cancellation of LPC.
Also went for the petitioner, so the already playing part is completed. Rejoinder has been filed against the respondents 5 and 6. So matter may fix for hearing. So I'm ready for hearing today, but they are seeking time.
Okay. We'll decide all this because now I have seen too many matters are going to hearing and hearing matters are not. This will be a boomerang for the bar members. I'm warning you. All these matters are going to hearing and I have seen 17 matters are not being heard. Situation is worse than Guwahati. Yes, and there is no part to hearing this. On the prayer of the learned counsel for the respondents, matter stands adjourned and be listed after 3 weeks. Interim order.
Lordship, I'm pray for this after 1 week, matter will list, since it is pending since last 2 years.
Okay, and after
1 week.
list this matter on 12. 12.
12. Much appreciated.
Lordship, item
This is
number-
a cancellation of LPC, is not it?
Lordship, item number 18.
Item number
18.
18.  18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18. 18.
for-
Yes.
On behalf of L Permit, standing counsel.
Where is the petitioner? Have you taken
Yes,
consent?
we have informed them, Lordship.
Okay. Informed?
Yes.
Yes. On the, as agreed to by the learned counsel for the parties, list this matter,
After
3 weeks, 2 weeks,
2 weeks, Lordship.
2 weeks. Review DPC. Yes.
Lordship,
There is,
and Lordship, item number 25.
25.
We have taken the consent of the other party.
Orders, just wait for some
We
time.
are yet to file, Lordship.
Why this matter is listed for orders? What is the office note says?
We're
Are
yet to file affidavit, Lordship.
Who is yet to file affidavit?
For respondent 1, 2, and 3.
Okay. That is the office note.
Yes.
Have you gone through?
No, Lordship, but we are.
No, don't.
still-
We'll see the order method will take 5-10 minutes, wait for some time. If nobody is there, we'll pass the order accordingly. Yes.
Your Lordship, I would like to mention item number 32.
32. All hearing gone.
The leading counsel, Mr. Epadachaji is ill.
32.
Yes, Your Lordship. Leading counsel is ill and is under medication, so he has asked me to take adjournment. And if the matter may be listed after 2 weeks.
On the prayer of the learned counsel for the respondent, matter stands adjourned and be listed after 2 weeks. Yes. Will issue a notice?
Yeah.
Will issue a notice at this stage?
Yeah. And in the meantime, my lord,
Hmm.
it may be club up with WPC 32 of 2022. 10%, WPC number 32 of 2022.
That is
21,
same person.
same person.
Let the notice return, we'll fix, on the next day Tuesday, we'll take up this matter together.
Oh, yeah.
Okay, on the return of notice.
Yeah.
Heard, Mr. Partin. M. Partin, learned senior counsel, assisted by T.Y. Bhutia. The grievance of the petitioner is that though the petitioner has been serving as lower division clerk within bracket LDC in the Department of Transport, Government of AP under establishment of District Transport Officer Pasighat since 1997. However, neither her case has been considered for regularization,
Yeah.
nor she has been paid the minimum scale of pay. Minimum scale of pay. Minimum scale of pay in terms of the determination made by the Honorable Apex Court in Jagjit Singh versus State of Punjab reported in so and so. First of issue notice, returnable. There are some matters in the hearing also like this.
Yes, 33, yeah, serial number 33.
Item that has been adjourned today.
Yes,
Okay.
government of the
Okay.
agenda.
Issue notice returnable after 4 weeks. Who accepts notice? All.
Yes.
As MS Swenso, learned State Council accepts notice on behalf of all the respondents, no formal notice need be issued. However, extra copies requisite number be furnished to her within a period of 3 days from today. Full stop.
Marvelous.
2 and 4. Yes, education.
2 and 4 are the same.
Malad.
So, my lord, since the 2 and 4 are analogous matter, my lord, so.
What is the procedure for appointment of CRCC? What is the qualification? Tell us.
My lord, for CRC, my lord, they are the TGT, substantive post is TGT. This is for temporary arrangement.
No, it's
for-
not temporary arrangement.
My lord,
CRCC is a cluster resource
my
coordinator.
lord, my lord,
BRC is a block resource coordinator.
my lord.
these teachers who are having experience, who is
Yes.
who are having leadership capacity are
Yes,
through a
yes.
selection process, put as an institute, it's a cluster.
As a additional charge, my lord.
It's an additional charge,
My lord.
but he is the leader of the cluster.
My lord.
He will have to look after how this Sarva Shiksha Abhiyan is implemented.
My lord.
Is that it?
That's true, my lord.
If that's true, we are not issuing notice today.
My lord.
We are fixing this matter on Friday.
My lord.
You will have to give us instruction. What is the manner and method
My lord.
mandated under Sarva Shiksha for appointment or even giving charge of a CRCC or BRCC. These monies are being spent by, not by the state, by the union government.
My lord.
A huge amount is given for upliftment of education.
Right, my lord.
They themselves has prescribed some procedure how this CRCC is to be appointed.
My lord.
Even if it is ad hoc arrangement, you will have to have the at least minimum qualification.
Right.
If there are persons available. If not, okay, fine. We can say that there is not a single person, you can do it. For insurance business, you cannot bypass the rule.
My lord.
So have your instruction.
My lord.
Otherwise, my lord, in the WPC number 299 and 298, my lord, this notice is already issued. And then, my lord.
So you want a notice only.
Yes, operating person of this impugn order has
Will
already
not
been
stay.
listed.
Will not stay.
My lord.
See, we do not want the institution as a whole to suffer.
My lord.
Okay. So therefore, we think it prudent to not to issue notice and have the instruction. Only then we will do a needful.
My lord.
We'll say that if we are satisfied, we do not know what is their instruction, under what circumstances they have given, what is the prescription. The present two petitions, 3 and 4, is that it?
Well,
Same order. It will be same order, no common order, same order. The stay will give you any benefit to you.
It will not.
Suppose we stay it.
my lord.
What benefit would you get?
Because-
Except happiness that I have stayed his appointment.
My lord, if we
Nothing
stay-
more.
If we state, my lord, at
And
least
we are not concerned.
I have an opportunity to, my lord,
No, that
we
will
consider
amount
my
to,
case.
that will amount to allowing this writ petition. Is that it?
otherwise, my lord, in due course of the time, my lord, if subsequent order pass and my lord, this,
No, we are taking on motion itself. You
Yes,
have
my
your
lord.
instruction.
My lord, earlier order, my lord,
And we expect,
my lord,
more particularly when you are the lawyer,
my lord, I'll
that
try.
will come with a proper instruction that this is the rule
My lord,
and we are following the rule, and if we have committed some mistake, we are withdrawing it.
my lord. My lord, and earlier, just to clarify, my lord, earlier order, my two cases, my lord, that was the case where the existing CRC was removed in order to accommodate the other. That was the,
No,
that
no,
is
we
why.
are not staying
Now
in
here
this
in
case.
this case, against the vacancy order.
No state. The petitioner, who is a head teacher at GPS Mapsoro, claims for the vacant post of CRCC. Full stop. According to the petitioner, he had applied for the said post, and the respondent number
respondent number 6 or
Six.
5.
Section 5 had also applied for such post. However, ignoring the seniority of the petitioner, the respondent number 5, who is much junior to the petitioner and
Right.
who has joined the service of teacher only in the year
1 years in the years 2023.
on the years 2023, have been appointed. Full stop. This court is from the perusal of the material. It is seen that the appointments of them are made on the basis of applications made by individuals. In the aforesaid backdrop, the learned standing council.
Yes, my lord.
Standing council for
Education, my lord.
education, school education, also
Yes, ma'am.
education, school education,
Common, my lord, all, yes, my lord.
education department
Madam.
shall obtain the following instruction for following instruction. 1, what are the procedure laid down for appointment of CRCCs, BRCCs? Second, two, what are the qualification earmarked for appointment of CRCCs and BRCCs? Three, whether appointments are made only on the basis of individual applications or through any advertisement. List this matter on Friday. 3 and 2 and 5.
4.
2 and 4.
4. In case of 4, the post is BRCC, madam.
Post is BRCC and respondent number?
Respondent number 5.
Respondent number 5.
Same.
Same. Other is post of BRCC.
If you apply.
Yes. Hmm. Yes, Nikita, what is this?
Your Lordship, there is only a single issue in this case, even though there are a lot of petitioners. The issue herein is whether before notification for land acquisition, any orders can be passed regarding the land. What happened in this case is land acquisition notification was issued much before that, precisely 1 year, 4 months before that notification, some order was issued saying that no construction should take place in that area. With that, in that proposed land. And then our cases were rejected, saying that you have constructed something on the way in violation of that order.
Okay, now tell us that order was passed under what authority?
There is no authority. I do
No,
not
there-
find any
There
authority.
may be sometimes why I'm saying you.
Yes,
Suppose in certain areas, more particularly, you cannot see, it is subject to further deliberation.
yes,
In National Heritage Act, there is some power where they can ask the municipal authority not to give permission.
yes. No, it is a
Okay,
village
which
area.
is one. Say suppose where there is an airport
Yes,
or army base,
yes,
they are having rules that there should not be a construction beyond this
yes,
level.
yes,
Though municipal act or bylaws permits construction of maybe 7 stories in that area, but by virtue of a notification of the union, they may say that no permission from there.
yes.
So there must be some authority asking you not to construct.
No, Lordship, no. Because in this case, land acquisition was, notification was issued under the Zoom Land Regulation Act. Under the Zoom Land Regulation Act, there is no procedure. There is no such
Now
procedure.
let us see the impugn that notification. Which writ petition will take?
Item number 10.
Item number 10, okay. Babuk Ringya, okay. Page 90.
Lordship. Impugn notification is, Lordship, page 67.
Page 67.
67.
Yes.
This is the notification dated 29 March 2021. This is passed by the Deputy Commissioner, Siomi District,
It is dated 29th of March 2020.
29 March 2021. Here they have said, whereas rampant construction of semi-permanent and permanent dwelling houses and other structure have been noticed on the hillside of Kaing Tato BRTF road from Penachek Gate to Tato, whereas it is suspected that such purposeless structures have been built with a malified intention of drawing excess land compensation amount in case of widening of the highway on the said route. Now, therefore, property assessment of no such structure built after 31st January. No date is, no year is given. It's not specified. Satellite images will be relied upon and which are built within the ROW shall be done and shall be taken under consideration while framing the estimate for land compensation amount to be paid to the landowners for the purpose of widening the highway in that route, and further similar constructions within Tato Township will be demolished without prior notice. Now, Lordship may see this notice. They have said 31st of January. 31st of January, which year, that is not mentioned. Then Lordship may see page 85. Page 85.
Page 85.
85. This is another public notice. This was issued after the notification for acquisition of land. This is 12th May 2022. Here, public notice is given. Whereas it is reported that preliminary road alignment is being carried out on the stretch of road from Tato to Monigao for construction of double lane road by the representatives of Ministry of Transport and Highways, Government of India, where it is suspected that such purposeless structures may be built with manifold intention to obtain excess compensation amount in case of widening of road on the said route. Now, therefore, property assessment of no such structure built after 30 June 2022 and which are built within the PROW shall be done.
So earlier was within
31st of which year? We don't know. 31st of January.
Issued on
20, Lordship?
That earlier notification issued on 21.
21.
So we assume that 31st January 2021, since it is issued in March.
That is open to assumption, but I'm pointing out this, Lordship.
No, I understand.
Yes.
Now, assuming for a moment that January 21st.
Yes.
Then
this is the date again here. Same thing, but the date is different. 30 June 2022.
Okay.
So we don't know which is which. They'll have to explain, which they have not explained actually. Now, Lordship, is one thing is very pertinent, Lordship. Lordship may see the last page of the writ petition. This is a office memorandum issued by the Secretary Land Management.
Page
197, the last page of the petition.
197.
The absolute last page.
What is the judgment you have relied on?
This is a judgment in which land acquisition was done under JLR, but some solitary men were not paid, saying that under the JLR this is not permissible. But this honorable court held that because under JLR only the substantive right of acquisition is given, but the procedure is not given. So therefore, the procedure to be followed would be the
compensation.
yes. That
And
is.
what about the compensation?
Lordship?
What about the compensation determination?
That also, because there is nothing is given in a
That
JLR.
must be under the Central Act, Fair Act.
Yes, under that.
Because the Act itself says that state will have a power to do, but it is not in the schedule maybe. Anyway, okay, that
Yes.
is not. Okay.
No, in that judgment which I have relied on, it is only to say that procedure under the LARA Act should have been followed. Because the JLR does not provide for anything other than saying that land can be acquired. So they have, as under the jail, in view of the judgment and also in view of the JLR provisions, the Department of Land Management has issued this memorandum. Lordship may see para 4 of the memorandum. Page 197.
Yes, paragraph 4.
Paragraph 4. The reasonableness of compensation shall be ascertained by giving due regard to the valuation of land and standing assets on the date of the notification under JLR 1947, their nature, including agriculture, horticulture, crops, damage, demerge thereof, and the loss of income to the individuals, community rights holders till the opening of the till the passing of the award order. So what this notification specifically says that the due regard should be given to the valuation of the land and standing assets on the date of the notification. Now let us, Lordship, come to the notification.
So, first notification debarring construction
Yes,
is 29th of March.
2021. It is a
29
public notice, in fact. It is not a
29/3/2021.
yes.
Okay.
Yes. Page 67.
Page 67. Then second,
The notification itself.
second is dated 20,
Lordship, sorry. That was, I think,
August something.
12 August, I think. 12 August 2022.
12 August 2022 with effect from page
Page 85.
68.
Lordship.
Page, the
Page
second
80.
notification.
Yeah, with effect from 30 June 2022.
38/2022 and March is
31st January. We don't know the date.
31st. It will be also 2022. 2022. Okay. Now that notice dated, just now we have said page 190
Oh, that is a memorandum.
memorandum.
Yes,
is of
that was
June
issued on
2020.
2/6/24.
Huh?
Oh, 2/6/21, sorry.
2/6/2021. Applicability of law.
Yes. That is in terms of the case which I have, yes. Then also, Lordship, now the actual notification.
Actual notification.
Actual notification is 24th May 2022.
24/05/2022. Okay.
This is at page 66. This is the notification for acquisition.
Yes, 66. Just a minute. Yes, what you say? 66.
66.
Okay.
This is, the notification is dated 24th May 2022.
Yes.
And before that, a notice was issued for assessment. That is the previous page, page 65.
On which date?
11 February 2022.
This is notification.
No, this is notification dated 11 February 2022 for assessment.
Page.
Page 65.
Okay.
As per the Lara Act, although I have not mentioned here, but as per the Lara Act, preliminary notification is under section 11. Then survey and entry upon the land is in section 12. As per the Lara Act, after the preliminary notification is given, then survey and assessment is done. In this case, what happened is assessment was done earlier, that is 11 February 2022. Then thereafter, notification was issued on 24th May 2022.
So, all this has been done.
Reverse, in a
No,
reversement.
no. Subsequent to the notification issued pursuant to this court judgment that LARA should be applicable.
Yes,
This is your case.
yes. Also, Lordship, specific cases, before the notification, it is my private land. I can do whatever I want to do with my land. Nobody has got any right to say you build this, you don't build this, you do that, you don't do that.
If they can do that, provided there is some law.
Yes,
That
provided,
there is municipal act, municipal.
yes,
That there is a procedure under urban areas or rural development, whatsoever that
Yes.
panchayat or somebody will have to give permission. That
Yes.
is not there. That will also be not for relatable to compensation, but order can be issued saying that don't do construction in this area.
yes.
That power they can exercise if they are having it.
That order, the impugn notice,
Hmm.
that doesn't emanate from any source.
Hmm.
Because the power that they're having to acquire the land is from JLR.
Hmm.
And the High Court order says, in terms of if you're acquiring under JLR, you have to follow the provisions of LARA Act. So from the LARA Act, both these statutes do not provide for any assessment even, not just this notification, not even an assessment before the notification. Under the LARA Act also, at first there should be a notification, then thereafter assessment. In this case, what happened? Assessment first, then notification. Then before that, again, this kind of order. This kind of order can be passed after the notification is issued. Then they can do that even before acquiring the land.
Because
So-
land will rest on the government.
Yes,
It will not, there no more will remain a private land.
yes.
It will rest in the government.
Now, what they have done is, we have made several representations. There, of course, there are disputes saying that we have made late, not made late, but there was a verification, there were so many verifications. In the verifications also, they did not make any finding except for the fact that you have constructed before in violation of that order. Now, they have made 3 lists. One is list number 1 is the accepted list, which they have called accepted list. List number 2 and 3 are those lists which are not accepted by them, saying that it has been rejected in view of violation of the disease order.
Which this?
That also is not mentioned, only disease order. But we are presuming it's the 29 March 21. So that is the case, basically.
Now, what kind of relief we can give you? These orders are specifically under challenge.
Yes.
Yes, state.
My lord, I am for the respondent number 4, Deputy Commissioner.
Now you are the man.
Uh,
You should tell us that under what authority you have issued notification, that's all. If you say that this is my power, if this is given to me, I have a power. Matter ends there, will throw them out. If you say I don't have any power, somebody has requested that see people are constructing for benefit of compensation, so I issued an order.
Yes, my lord, kindly see my affidavit in opposition in Babu Grinya.
Affidavit in opposition, where do you get that?
And my lord will find it page number 9,
Where do you
10.
get that affidavit?
affidavit in opposition. Babu Grinya.
By respondent number
4.
we are not interested in facts. Neither from the petitioner nor from you. We are not interested who has constructed 4-story building or 5-story building, or we want first the power. That I have this power and I have issued this power in exercise of this act. So therefore, there is due process of law. Due process of law followed.
Yes, my lord. Page number 10.
Page number 10. Affidavit filed by Takam Tissue. Respondent number 4. Huh?
This is a letter, affidavit in opposition.
No, it is a respondent number 4.
4.
Page 10.
Page 10.
This is a letter which is written by the proforma defendant number 6 to the Deputy Commissioner, saying that encroachment to the Deputy Commissioner, Siomi District, Arunachal Pradesh, encroachment of BRO land by civilian between Pene to Tato on Kaing Tato Road. This is letter dated 20 March 2021. Prior to that order dated, public notice
Let
dated.
understand, here is the bureau says that we have already paid compensation and
Yes.
there is an enforcement.
Yes,
But your notification is subsequent to this. This letter do not have any nexus with the acquisition. This might be a different land.
It is a different stretch of road. That is why.
Maybe. Because therefore it says that amount of land acquired, this relatable to an acquired land.
yes, but that this order 29 has the reference of this letter. 2011.
So according to you, the letter has been issued by the Deputy Commissioner on the basis of this request by officer in commanding officer.
Yes,
This is your.
yes.
Okay. That is not the authority of law. That might be a request. That's not an authority under law. Yes.
Thereafter, this notice was issued, thereby restraining them to further do the illegal construction on the right of way. And this was admittedly, it is on the record, this notice was issued prior to the notification, but it has nothing to do with when this was issued, this has nothing to do with the acquisition of land.
So if nothing to do with acquisition of land.
When this was issued, this public notice was issued, because they were encroaching the right of way of the. Thereafter, acquisition was done under section 10 of the JLR Regulation 1947.
The JLR regulation.
And in that act also, there is no embargo which barred the Deputy Commissioner, District Collector from issuing such notice. And after issuing this notification, claim and objection were entertained. They have participated in all the land acquisition proceeding. Claim and objection, numerous claim and objection were entertained. Series of meetings were held with all the stakeholders and landowners. And thereafter, spot verification was done along with all the stakeholders and the landowners. Verification was completed. Thereafter, only when their name appeared, lists were prepared. List 1, list 2, and list 3.
What is list 1?
List 1, they are the one who are entitled to payment of compensation. And list 2, they are who are not entitled to payment of compensation because in violation of the public notice dated 29 March 2021. And list 3, they are also rejected list in violation of the public notice dated 2020.
Just let me just record the facts for the timing. Take down. Then we'll proceed further. Madam, take down. This present batch of writ petitions, since we have spent time, we'll close it. This present batch of writ petitions are taken up together for final disposal today. Full stop. Claiming that
I'm sorry, my lord. Just one thing I would like to clarify. Just now I have been informed that the judgment which I was relying on has been stayed by the Supreme Court. the judgment which I was relying on has been stayed by the Supreme Court, but other facts remain the same.
When it was there? What was the division bench? This was a single bench judgment.
Division bench. The matter has gone to the Supreme Court.
Only this part has been stayed, my lord.
Which part?
In that referred case, my lord, basically they are claiming, the landowners were claiming, my lord, the solism and the interest, my lord.
No, see, what was the judgment says? Judgment says, then there maybe we might have to adjourn this petition because whole basis is that case. Because my view is also so far relating to see, basically in that Fair Compensation Act, what it's a central legislation. Fair compensation is a central legislation. Fair compensation says that state can make, because there is some entry for legislation, state can also make its own law. State can make its own law so far relating to the land acquisition. But such law cannot be less beneficial than the
main act.
fair compensation. This is one. Second part is that then when there is an absence of procedure, acquisition process is given. Of course, that is to be done under something. Either government will have to do something in this regard. And I myself is having a question in my mind, whether they are having any power even to acquire land on the basis of this act. Where is that power? After coming into Lara Act, everything is wiped out except certain acts saved in the schedule.
Admittedly, the acquiring authority has to form a decision by which the act
No,
will govern.
not acquiring. The parliament of this country has enacted a law saying that this will be the procedure.
That issue has already been addressed in the in the relied judgment, and because of that, the decision, this honorable court has given the directions for the even payment of the compensation, even if the acquisition process is done under 1947 regulation.
Because see, there are two parts. Law is well settled. When the act itself says, when it will bring an acquisition process under the fold of the Lara Act, at what stage? Section that has been interpreted. There was what development authority? Pune Development Authority or
Indore Development.
Indore Development Authority. Then another judgment referred to a larger bench. So ultimately, that conclusion is made.
So this honorable court.
And the act itself gives some certain schedule where it says that this act will not come into the fold of this act. Otherwise, that will mean, what will that mean? Madam, I think we should adjourn this matter today.
Lordship, we are in
My lord,
in a
my
tearing
simple
her.
submission, my lord. In my case, my lord, is independent of own, my lord. It's not connected with those Mihilanil case or my lord. My case is, my lord, I am not seeking anything, my lord, extra, my lord. Rather, my lord, the land acquisition.
No, simple issue is, see, that's why I wanted to dictate the dates. See, if we go by the dates, the notification pursuant to this judgment, court judgment, was issued on 24th, isn't it? 24th of May 2022. Okay. Even if we assume that subsequent to this date, the land acquisition is to be proceeded in terms of that regulation. Okay. So therefore, after that, this whether they was within their right to process, initiate the process in terms of that act, Balipara Act. Because they themselves say, pursuant to this judgment, that the procedure should be followed under this act. Isn't it? Land acquisition process started on acquisition notice was issued on 24th of May. Isn't it? 2022. Then, oh no, 2/6/2021 it was made applicable. Okay, there is a distinction here. 12/8, then 38. So after 2/6/2021, can these two orders be passed? Here subject matter is this, but
Lordship-
now
Lordship, except for the procedure that is being followed, with regard to
can I have the order of the Supreme Court or one line stay?
Lordship,
State, my lord.
So if that judgment is stayed, then we will not be able to comment on that. And since it is sub judice, again same view, it will be difficult to express. Do you get my point?
yes, Lordship.
Because there will have a bearing on this point, that whether which.
Yes, one thing, my lord. By this order, my lord, my lord.
No, give me a copy of this order,
Court's order.
that Supreme Court's order. Give the number, we will right now have it. SLP number. State. SLP number. It will be a long number. Anyway, tell.
My lord, my lord, we are confused by this, my lord, order of 2nd June 2021, whereby it says in the last column, my lord, para 5, further order of the Honorable Governor issued on such and such in appeal, that is, such and such, land acquisition is forward for guidance and the strict compliance, my lord. Here, my lord, initially, my lord, the landowners were of the view that, my lord, under the, my lord, Zoomland Act, my lord, they can file an appeal to the governor, my lord. My lord. So, my lord, instead of, my lord, filing appeal to the.
Okay, forget about it. Now tell us, thereafter, when 24/5/2020 notification was issued, then the land acquisition process was followed under what provision?
No particular provision, Lordship. There is
After that notification, also no particular
no
provision.
particular provision.
Any award pass?
They just like I said earlier, only 3 lists were prepared: accepted list, rejected list, and another rejected list. Only on that, and then some compensation has been paid. Compensation has been paid to us also, not in respect of these properties, but in respect of some trees and horticulture
So
production.
your payment is obstructed by these two notifications, 22nd of August and 29th of March,
12th August.
or 12th of August and 29th of March.
Oh, it is not clear whether it's 12th of August, because in the reject list, it is simply written violation of this order.
Now, what is the
Which
stand-
order, we don't know.
What is the disease order? What is the stand of the Deputy Commissioner? On what basis?
They say
According to him, this is the 29th, is not it?
Yes.
that is in the affidavit, but in the order itself, it's simply written violation of this
therefore,
order.
what is the relevance of the judgment in this case?
There is no relevance except to say that even under the
So
Lara Act,
that if we do not deal with that part,
yes,
only deal with this part,
yes,
their rejection was right or wrong.
yes,
And they will have to reassess in terms of our decision.
Yes,
If we say
yes,
that their decision was correct, you are
Yes.
out of this court.
yes,
If we say that their decision on the basis of Deputy Commissioner itself is wrong,
yes,
then they will have to do a reassessment.
yes,
That's all.
yes,
So that is no relevance of that judgment.
yes,
Okay,
Lordship.
proceed.
Yes.
Proceed. We will not go to that finer points, that which has already. What is the which page division bench judgment?
One 69.
My lord, this is spoken judgment.
169.
Huh? 160
Page 169.
judgment.
Yes. Justice Borwa, A.M. Bujar Borwa and Devashish Borwa. This is a division bench judgment, 169.
Page one.
This is just to rely only on the point that,
No, I understand. That
yes.
is basically,
yes. Because the JLR does not provide for anything other than the power of acquisition.
okay, forget about that. Let us taste this deputy commissioner's order. Okay, fine. Yes,
My lord, wrongly or rightly, the rejection of compensation was done on the basis of the public notice dated 29 March 2021. Only on that count only the rejection was done. And my lord, I may submit that per se is illegal, then it has to be illegal from the day one. They have participated in the entire proceedings. They have submitted their documents. They have received some amount. And when their names appears in the reject list, now they have come before this honorable court saying that they are agreed by this public notice dated 29 March 2021. So is it justified, my lord?
so you want to say they are
So they have waived their rights.
waiver and estoppel.
Yes,
There is no estoppel against law.
my lord, that is
You
there.
are not in equity, what it is there. It is there, always there.
It is there.
You are in a reed court, not sitting as a civil judge.
So only this much.
There is no estoppel against law. Yes, that is your argument.
Yes, that is my only.
Yes,
humble submission.
highway authority. And you are for land management.
Yes.
What is your stand? Order, including the order passed by the deputy commissioner. Did you file any affidavit? No. No. Only deputy commissioner has filed affidavit. Okay, let us just dictate these facts, these facts, then we will decide whether we will further proceed or not. We are dictating somewhere. What was the last line? For final disposal. As these writ petitions involves common cause of action and challenge made are also common. Full stop. All have challenged this notification? Huh? And 27th of October 2022, issued by the Deputy Commissioner of C. Yomi district, Arunachal Pradesh are being challenged. By the aforesaid two orders, the Deputy Commissioner has prepared a list enlisting the persons who claims land acquisition compensation, and the list is marked as rejected list. Full stop. The further challenge made is an order dated 29th of March 2021 passed by the Deputy Commissioner, whereby certain persons / citizens / the present petitioners were asked not to carry on any construction over their private property. Full stop. Subsequently, similar notice was also issued no, not necessarily issued. Full stop. The ground of the petitioner to challenge the notifications dated 9 December 2022 and not notification, order dated 9 December 2022 and order dated 27/10/2022 is that such a rejection has been made only on the basis of the order of the Deputy Commissioner dated 29th of March 2021, is as much as it is the case of the petitioner that their claim has been rejected for the alleged reason that their houses were constructed divorce the order issued by the Deputy Commissioner by its notification dated public notice dated 29th of March 2021. Full stop. The fundamental ground of such challenge is that the Deputy Commissioner is having no sanction and authority under law to issue the notice dated 29th of March 2021, which resulted in violation of the petitioner's fundamental right under Article 21 as well as under 300A of the Constitution of India. Constitution of India. Full stop. Constitution of India. And therefore, according to them, they cannot be deprived of their compensation for the land and properties acquired by the state only on the ground that has been constructed in violation of the notice dated 29th March 2021. Therefore, consequently, the orders impugned are liable to be set aside. The Deputy Commissioner has filed an affidavit and has taken a stand that the the executive engineer civil officer commanding had written a letter to the Deputy Commissioner alleging encroachment of BRO land by civilian between PENE capital to TATO on Kaing Tatu Road. It is the contention of the Planning Council for the petitioner that on the basis of such request, the public notice dated 29th of March 2021 issued, 2029 was issued And therefore, it cannot be said that Deputy Commissioner has issued the order without any sanction and authority under law. Inasmuch as the Deputy Commissioner, being the head of the district, shall have power to issue such an order to stop construction. He further contests that pursuant to the land acquisition process, the petitioners had participated in the negotiation and assessment and survey, and when their claims were rejected, then only they have become wise and approached this court for redressal of their grievances. Therefore, they are estopped from raising such plea. These two are your grounds?
Yes.
These two are the grounds. Before dealing with the arguments advanced by the learned counsel for the parties, let this court first record the facts which are not in dispute and which are discernible from the pleadings made by the parties. On 11th of January, just a minute.
The assessment order, Your Lordship, 11 February
11 February,
22,
yes,
page 65.
just a minute. Eleventh of February.
Yes,
Huh.
2022.
It's 24, is that it? On 11th of February 2022, the Deputy Commissioner, C. Yomi District, issued a public notice issued a public notice in exercise of its power conferred upon the said officer in terms of office memorandum dated 3rd of June 2021. For carrying out the assessment of structures, trees, and any other properties standing in the proposed right of way, PROW, for construction of double lane road from Kaing to Tato. Full stop. A committee was constituted, and it was proposed that the assessment will be made with effect from 17/7/2022, and the assessment report is to be submitted on or before 28/2/2022. Full stop. Subsequently, on 24th of May 2022, a notice under section 10 of Balipara/Tirap/Sadia Frontier Track Zoom Land Regulation 1947 within bracket in short Regulation 1947 was issued. Whereby intention of the government to acquire the scheduled land for construction of new alignment, widening / improvement of existing road to two-lane national standard NHDL Keing Tatu Road from Pene Village. Just mark it page 25 pencil marker. French. Thus, the scheduled land was notified for acquisition under section 10 of the Balipara under the regulation 1948. Full stop. Prior to that, on 29th of March 2021, the impugned public notice was issued, which is quoted herein below. Page 26. Okay, page 26. Page 26. Yet another notification public was on 31st of March in the similar line in date of 29th of March 2021, notifying that, where is the date here? Whereby it was notified that whereby objections to the assessments were sought for, is that it? By 27?
Lordship.
Page 27.
Page
Decision.
27 of this affidavit.
No, you read petition. This is basically the objection.
No, Lordship, your Lordship must be taking up the wrong one because in my writ petition, these are all
I'm
names.
taking up 131 AP. WPC 131.
Lordship, this is the item number 10 is WPC 3. WPC 3.
Okay. Just wait a minute. WPC
3.
53.
303. 03 of 23.
Okay. So many files. Okay. 29th March, I have said, 30, thereafter, yet another notice, just delete the earlier paragraph. After 29th, now it will be thereafter. On 31st March 2022, another notice was issued seeking objection and claim, is that it? Seeking claims and objection as regards the assessment already made, is that it?
Yes.
Already made. Thereafter, the representations were filed by the
Yes.
petitioners raising
Several.
several petitions were filed raising objections. While the matter was at that stage, and public notice was issued on 12th of August 2022. This is not relevant.
Lordship.
This is not relevant. August, because this is subsequent to assessment and notification.
Yes.
This
of course.
is not relevant.
Just to show that,
That
the
they have
dates
done, one second.
are not clear.
Thereafter, committee was constituted by the Deputy Commissioner on 13th of August 2022. There was another order was issued by the Deputy Commissioner on 13th of August 2022. A reassessment was directed to be carried out of properties standing in the proposed right of way and submit a report within 45 days from date of issue of the order dated 13th of August. Accordingly, public notices were issued by notice dated 22nd of August 2022 for such reassessment, and subsequently by an order order impugned dated 27th of October 2022, a final a list were published on the basis of such committee, and a list number 2 was prepared whereby the claim of compensation was rejected on the ground that, where is that ground?
Lordship, the ground of rejection. It is in the list itself. That starts at page 93.
Page
93.
On the ground.
It is written rejected, constructed in violation of this order.
On the ground that property included in the Siang, on the ground that rejected, which list? Page 93.
Page 93. In the top, it's written.
In the rejected, as the construction was made in the violations of this order. Full stop.
Dated 29/3/21.
Dated 29/3/2021. Dated that is there 29/3/2021. Full stop. Yes, arguments are over. This is the case. We have a letter. This is argument.
I would like to, of course, clarify that they have said that we have received some compensation. We have received some compensations, but it is not with regard to this properties. It is with regard to some trees and all. There also the rate was not okay, so we had filed another writ petition. That is a subject matter of another writ petition. Just to clarify that.
Okay, let her type this part, then I will dictate my final part.
Yes.
Okay, going through this.
Text, madam, I want to clarify, madam, in my repetition, madam.
What is the ground of rejection for you?
Same ground, my lord.
List 2. You are also all are list 2.
List 2 and list 3.
What is the list 2?
Same.
We are only
Same.
petitioners 2 in number, my lord. And my lord, same ground, my lord, 29/3/2021 would not have a ground for my lord rejecting the our assessment matter for our assessment matter and compensation matter. Yes, because my lord, land notification was issued only on 24/5/2022.
See, there are two parts. One is assessment part. One is entitlement part.
Yes.
Assessment they have made. No
There
doubt
are
about it.
two-
Because the notification was for assessment. So therefore, they had participated in the assessment. Now result is bad. They have failed in the exam. Therefore, they have challenged it. They thought that they will be given. So therefore, they participated.
In my case, I have not participated. My lord. In my case, my lord, on the date fixed for the assessment, my lord, the officials never came to my place, my lord.
Have you made a statement?
Yes, madam.
What is their reply?
They have not filed affidavit in my case, my lord. They are saying
Therefore, we will not go to all these facts.
my lord, yes, my lord. My lord, there are two categories of orders passed by the Deputy Commissioner, my lord. First category of orders, my lord, were passed prior to the land acquisition notification, which was on 31/5/2022, my lord. The first order, my lord, has already seen, my lord, 29/2023, whereby Deputy Commissioner has fixed a date. Who will be entitled for the compensation, my lord. And in my case, I have specific amendments made, photographs were annexed,
electricity.
We cannot decide that.
Madam?
Whether you have done it or not done it, then you'll have to go to the referral court.
No,
You'll have to
madam.
establish by evidence that this building was constructed on such and such that. See, may not be a specific order, award, but this is an award. Award of compensation. Okay? Now, award of compensation when is challenged on quantum not satisfied or otherwise apportionment, it is to be decided by a fact finding, either the referral court if there is any provision, if not by a civil court. This court cannot decide.
Yes, sir.
What this court is deciding is whether procedure adopted in rejecting is correct or not.
That's
Will
correct.
either say correct or say not correct. We said if not correct, they will have to, why not correct will give the reason. Then they will have to give you the assessment as they make. Moment you say that my building is, they make it assessment of 2-storied, my building was 5-storied. No, we cannot touch this. That is to be established.
No,
If you,
I am not on that, my lord. My lord, I am on the, my lord, because my lord, as I say, submitted, my lord, there are two categories of order passed by the deputy governor. Or some orders, my lord, prior to the, my lord, notification was issued. And after, some orders, my lord, after the notification was issued, my lord. That's what I want to point out, my lord. Is because, my lord, first, my lord, the public notice, my lord, 29/3/2022 is bad in law, is because, my lord, it itself is a non-existence existing law. After the passing of the 29/3/2021, the order passed by the Secretary Land Management, my lord, whereby it is said that, my lord, the date of, my lord, fixation of the, my lord, assessment of the compensation is the date of the notification, my lord. So by this notification itself, my lord, that notice goes, my lord.
no, do you say, if you say that whole assessment should be done afresh in terms of the Land Acquisition Act, then you'll have to adjourn this matter side right.
No, not exactly, my lord.
Keeping
That's why, my
that,
lord,
keeping that
when-
question, will keep that question open in view of the judgment. That there is a stay of the judgment. This was the view that land acquisition compensation shall be entitled under LARA. However, the judgment has been stayed. Therefore, in the future, if they shall be at liberty to raise that point in appropriate forum, maybe in the referral court. Now, beyond that, what do you want? Tell us, Mr. Sekia.
my submission is that, my lord, they cannot make a basis, my lord, of, my lord, 29/3 as a, my lord, cutoff date for, my lord, assessment of the compensation.
In addition, Mr. R. Sekia, just somewhere type it. I will just give me a printout then. In addition, Mr. R. Sekia, Learned Counsel submits that pursuant to notification dated, governor's notification.
31/5/2022.
31/5/2022, prescribing mode of assessment and fixing a date.
No, that is, my lord, notice dated 29/3/2021, my lord.
No, that we have already recorded. That 29/3 cannot be basis. You are saying that that notification was issued on which date? Pursuant to this judgment.
No, land acquisition notification was issued on 35, I am saying, 31/5/2021.
Understand? Land acquisition notification was on 31st.
Yes, my lord.
And assessment was prior to that.
Prior to that.
Prior to that assessment, then land acquisition, then they have issued 31st of March. Isn't it? So therefore, on 29th, they cannot. This is your argument. What is your argument? Otherwise, I have recorded your argument.
My lord, my only argument is that, my lord, that first the public notice, my lord, 29/3/2021 cannot be the basis for denying our compensation.
That we have already recorded, isn't it?
Yes, my lord.
We said that Deputy Commissioner is not having your argument, we have concluded, not having any power to issue such a notification, and such notification cannot be a reason to deprive a person's entitled for compensation. That we have already recorded.
And, my lord, after the land acquisition notification, my lord, public notice was issued on 31/5/2022, my lord, whereby it also said that, my lord, the property which were already, my lord, the property created after 29/3/2021 shall be, my lord, barred for compensation, my lord. That public notice itself said, rest property are displayed for compensation seeking claim and objection.
Which notification you are reading it?
31/5/2022.
Ah.
My lord. And my lord, and my lord, that in that notification and further 30 days time was given for claim and objection. Accordingly, my lord, we have filed claim and objection. And by that, my lord, DC directed the board to carry out further assessment, my lord. And my lord, the chairman of the, within 45 days, my lord, the properties which are in the proposed right of way, my lord. The chairman of the, my lord, committee, an assessment committee, has further delegated the, my lord, assessment to the subcommittee for identifying the, my properties, my lord. In the subcommittees, my lord, who are the subcommittees, my lord? Subcommittees are some private persons.
You are going far beyond.
Yeah.
If we set aside, then we'll have to dilute that whether they have the authority have to have an assessment, then whole assessment will go. Everybody's assessment will go. If everybody's assessment goes, make them a party.
I am my
No,
concerned
don't,
in my
Mr. Saikya. If you argue something, we'll have to address it. We will not shy away from arguing it, addressing it. If you say that subcommittee's assessment itself is wrong because it has delegated its power and it is not having any power to delegate, therefore such entire exercise is bad, we may set aside entire exercise. Bring all the persons under list 1 to be respondents.
in the, my lord.
No, don't go side, don't shy away. We are not shying away.
Then my lord,
Is it not?
yes, it is.
If you say that an assessment has been made and by an authority without sanction authority under law, as you are saying as regards deputy commissioner, if no authority, everything will go. If it goes, then we'll have to hear the other respondents.
So my be it that may be, my lord. Ultimately, my lord, the assessment has been rejected on the basis of an order, my
That
lord,
means that
prior
we have
to the
already-
land
that we have
acquisition
already
notification, my lord.
recorded, Mr. Sakya.
Yes, my lord. Then, my
If
lord,
you want to
that-
add something, please
that
add.
rejection order and the subsequent circular whereby it sent, my lord, eviction order, my lord, to evict us, my lord, from our land, my lord, land and property, my lord. It's also violation of the principles of eminent domain, my lord. Without paying compensation, my lord, they cannot.
No, that we are not agreeing to that argument. If the public project is required, it is a ROW. They have made assessment, you have participated. Today, you cannot say that don't
No,
allow
my
them to
lord.
construct. What is the status of the construction?
Admittedly, my lord, the properties
Construction, what
are.
is the status of construction?
My lord, construction is for, my lord, basically defense strategic importance road, my lord. So therefore, my lord, this is an important, my lord, the road to be constructed by them, my lord.
Okay.
So it's going on
saying it's, so even if we participated or not participated, it would amount to the same result because they are only referring to that.
Whole case is whether they can pass this order
Yes.
on the ground that 29 there was a bar and your building is beyond.
And
50.
also, Lordship, in my affidavit in reply, I have specifically replied that we had no, in fact, we had no notice of that, that 29 March order. Only after these things came into being, we came to know, okay, there was this order.
You do one thing, give a short bullet note of argument.
Yes.
Yes, Mr. Sakya, you also, but not lengthy 5-6 pages.
Yes.
It is 1 page or maximum 1.5 pages.
Yes.
Just your bullet points. This is your arguments.
Yes.
You can also give, everybody can. We are taking up this matter when
Dispose it of today because they have started the construction. We have filed a contempt petition.
What
Also,
if
no use.
Suppose we allow this petition, ultimately they will pay you the compensation.
But since they have simply said we are rejecting, they have not even made, okay, this much is the house, this much is the boundary wall. These things have not been done. They are simply saying yours is constructed before in violation of the dead order. Now they have
But there is
started.
an order, stay order here.
Yes.
Yes, Kato, just wait for 2 more days, don't do anything.
This is important road, madam.
No, important road, but the Supreme is the court,
Madam,
not you.
madam,
File a stay vacating petition, don't say that.
madam,
We have filed a contempt petition also.
File
They
a
have-
stay vacating, this court is very strict so far relating to court's order. We may be wrong, go to an appellate order,
Madam,
appellate,
assessment-
or file a vacating.
madam, assessment, everything has already been done by the district administration, madam. Accordingly, we have paid, madam. Now the question is, that payment made is part of the, madam, that right of way or not, madam. That is one aspect, madam. From the authorities, madam, everything has been clear. So therefore, madam, it has
We
to,
understand, we are not saying you have not done anything.
madam.
But can you say since we have done everything, we will not follow court's order? That is the question.
No, madam, it is not my submission, madam. Madam, my submission is, since we have already paid for constructions of the importance road, that is
That we
the,
understand.
that is
Therefore, we have
the, that
taken
is
up this
the
matter.
final and the, madam, the final payment made by the defense authorities, considering the importance, madam, and the development project
No,
work,
no,
madam.
we understand everything.
Madam.
Generally, we do not ask interim order in land acquisition process when it's a public process. What maximum order can be passed is make a proper assessment, keep it in a seal cover or keep it separately.
Madam.
In these cases, assessment have been made, but their claim is rejected.
So therefore, madam, since if it is.
No, therefore, there may not be a good reason to remain the stay.
Madam.
That can be decided by a court,
Admittedly, madam.
not by you.
Madam, yeah, exactly, madam.
Exactly, don't touch anything. Then day after tomorrow, everybody should be here. We'll draw suo moto contempt. If there is a stay, where is the stay order?
Madam, in that case, madam, I may be allowed to take instruction.
You have instruction, we are delivering this judgment day after tomorrow, say.
Madam.
Because I want their bold note, I will just, I have dictated the order, first part, I will go through and pass the final order.
Madam, we are executing the work by virtue of the notification issued by them and the district administration, madam.
Oh, we understand. You have been allowed to issue work by a district authority. The road is of public importance. Fine.
Madam.
No doubt about that. Only question is that if there is an order of stay, that is to be respected by everybody.
True, madam.
Number one, how so big he is, or otherwise, if anybody is aggrieved, he can go to the higher authority. That's just like the state has gone against the judgment. So because the state, we do not know. So we'll have to respect that order as on date. I may openly say that, yes, I think he was correct. But that is, I cannot write that Supreme Court is wrong.
Madam.
Okay. So therefore, you also cannot say that we have done everything, so forget about the court's order.
Madam, I'm not sure about that,
Where is the order? Interim order, if any.
Lordship, in respect of item 10, it is on 24/1/23. No coercive action shall be taken.
At least petitioners, don't do it. We are taking up this matter. Give them immediate message. And if anything happens, file an application by tomorrow morning.
Lordship, we have already filed contempt petition.
No, contempt, no. Anything. What contempt will? Contempt will issue notice, put them
Notice
behind
has
them
been
bar.
issued already.
Nothing, contempt, nothing. But if anything is done, day after tomorrow, we are dictating this order in the court. So we are keeping it as a part heard. Some other matters is a fiction day after tomorrow. Okay. Yeah, hearing concluded. However, the learned counsel for the party submits that they may be granted chance to give a written note of argument, not written argument, written note of argument, and to point out any addition and to argue any additional point that may arise. First of all, please this matter day after tomorrow. Well, we'll dictate on that. Possible day after tomorrow to dictate, huh?
Oblige.
So that I can
Yes.
do it properly. Okay, then next item. Item number?
Yeah, we have filed our affidavit.
How this writ petition is maintainable?
Yes. Malad, basically it is the false affidavit, Malad.
False affidavit can be a cause of action for a criminal action. Okay,
Malad.
well, what happened to that writ petition? Writ petition is pending.
No, Malad, that has been disposed of.
Writ petition has not been allowed and no appeal has been filed.
Okay, even if we assume that I do not think this writ petition is maintainable.
Malad, in view of the Malad authority and the judgment Malad rendered by this honorable court, even it is reported in 2015.
What it says?
Malad, it says when Malad the false affidavit, Malad
So there is no problem on that. If false affidavit is filed, there is a procedure prescribed.
Malad.
I have forgotten the new provision under BNSS, but CRPC proceeding, how I myself as authored a judgment details how is to be done. How the complaint is to be filed, when it is to be, suppose it brings to my notice, I can direct the register to initiate an FIR, or it should be a complaint, even at FIR, it shall be a complaint case, not FIR. But writ petition is not maintainable. You can file a IA in that.
Writ petition, criminal, for directions for registration of the
No,
case against.
no, cannot be. Registration of what?
Registration of FIR against.
No,
the Malad.
no FIR is registerable under this provision. You will have to file a complaint by our register.
Malad, in such case, Malad,
We understand you have a cause of action.
Malad,
If somebody has made a
false affidavit.
No doubt that you have a right to bring to the notice of this court, seek an direction that this is the facts. Rest is up to the court. But no writ petition. Writ petition is not a writ.
When the party made a false affidavit, Malad, admittedly and fairly, Malad, and that has to be, Malad, there has to be some remedies. How?
Remedy is there, but remedy is not a writ petition. I will not express beyond that.
Malad.
Remedy is not a writ petition. What do you, let us read Article 226. What it says. What it says. Let us read Article 226 once again. What Article 12 says, let us see.
I'm sorry, Malad.
Writ can be issued against whom?
That is, Malad,
To whom will issue a writ here in this case?
Malad, may I read the Malad, the persons to which I have Malad, praying for a directions or order, initiation of the criminal proceeding against the respondent number 4 for intentionally giving the false and the fabricated evidence.
Direction to whom?
Malad.
Direction to whom? Is an FIR maintainable under this under the given facts of this present case?
Therefore, Malad, in one of the case, direction was given to the the registry for the registration of the FIR.
I have
Against-
serious doubt. It should be a complaint case.
Then, my lord, in that case, my lord, I may be allowed to, to file an FIR before the appropriate authorities, my lord.
I will not advise you.
My lord.
Neput Reidum, read that judgment. I think it has been reported.
My lord.
What is the perjury before this court and what is the procedure laid down and how it is to be proceeded?
That, my lord, may be allowed to go through, my lord. I'll come with the lordship.
Read will, of course, you can argue on the prayer of the learned counsel for the petitioner, matter stands adjourned and be listed when
After a week, man, I'll come with my lord.
Will it be after 3 weeks, my lord? I have to go to Kolkata. for
Up-
the
up.
patient.
what? Okay, after 3 weeks.
My lord.
19 and which 921?
Yes.
Yes, tell us.
Because inadvertently I have not met the Union of India and
Oh, that will allow. That I will allow. That you have, instead of Union of India, you have made some officers a party. I have seen that.
I may be allowed to make that handwritten.
That registry will do. IA number?
19 to 21.
No, which IA?
IA number
119,
119, 120 and 121.
120 and 121.
Yes.
Dispose of.
And in the main,
Main, give a date.
I may be allowed to take steps on newly added.
No, after registration, it will come back to the court again, then only notice. Or we'll see. Dispose of IA 119, 120, 121. Yes.
But,
Yes. One five. 16. Yes, affidavit in opposition.
Lordship, there is some subsequent changes in this petition because private respondent has died. I'm informed them.
Okay,
This is seniority matter come promotion.
okay.
At this is, I would pray for this disposal of this representation, which is pending before the deputy commissioner.
So you want just consideration?
Yes.
Hard Mr. Tapak. Learned counsel for the petitioner and MS
Arbasar.
Arbasar. The learned government advocate appearing for respondent number
1, 2, and 3.
You are Mr.
Respondent number one.
Huh? T. Ronan appearing for respondent number 4. Who had expired on any date, who had expired during the pendency of the, no, full stop, for respondent number 4. It is submitted by the learned counsel for the respondent number 4 that his client has expired during pendency of the present petition. Basically challenging the promotion of the respondent number 4 to the post of political assistant is challenged in this writ petition. Full stop. Learned counsel submits that as the respondent number 4 has in the meantime expired and post is still vacant and petitioner had already filed a representation for consideration of his case inasmuch as according to the learned counsel for the petitioner is qualified for promotion to the post of political assistant. And therefore, he prays that this writ petition can be disposed of, directing the respondents to consider his representation.
Deputy Commissioner, Yingkyung.
Deputy Commissioner, full stop. such prayer has not been objected by MS Basar Learned State Council. Considering the consensus at the bar as well as considering the death of respondent number 4, the present writ petitions and disposed of, directing the deputy commissioner,
That's respondent number 3.
respondent number 3, to consider the representation preferred by the petitioner on
Within the 30 days, it was filed on 4/7/2023.
2023.
4 July
Dispose of directing the writ petitioner to file a fresh representation before the deputy commissioner, that is the respondent number 3, for consideration of his case. Full stop. On such representation being filed, same be considered as per law and be closed by a speaking order. Full stop. Accordingly, the present writ petition stands disposed.
Within the 30 days, Lord.
Before that, you just write it. The entire exercise be carried out within a period of 6 weeks.
60.
Yes, that is arbitration matter, my lord.
May it please your lordships.
Yes, just let us hear him on the period
Yes,
of.
yes, my lord. My lord, only with regard to whether there is any live issue remaining and whether the so claim is barred by litigation. I'll just take your lordship to 2-3 clauses of the memorandum of agreement and why we are opposing, my lord.
Okay, paragraph.
My lord, I'll border, my lord, at page 82.
Yes. The 12.1.
Yes, my lord. My lord, before that page 75, my lord, it will be.
Yes.
Page 75, 2.3, my lord. The entire cost of investigation, DPR preparation, project implementation, and subsequent operation. 2.2 and 2.3.
2.2. Yes.
The project shall be implemented by MS so and so on both build, operate, own, operate, and transfer for a lease period of 40 years from the commercial operation date. The project shall be reverted to the state government on expiry of 40 years, free of cost, in good working condition, no extension, so and so. The entire cost of investigation, DPR preparation, project implementation, and subsequent operation and maintenance of the project will be borne by so and so. Entire cost, investigation, DPR preparation, everything has to be borne by it. My lord, then I'll take your lordship to direct page 82, man.
Yes. 82.
Yes, my lord. My lord will also come to page 76. That is 2.6, which is
2.6,
my lord, which is a bit.
All clearance as required. Yesterday I've shown it.
Yes,
all clearance
all-
that
all
required
clearance.
from the central government in connection with the project shall be arranged by the company
itself. All clearance shall be arranged by the state government shall accord necessary clearances under its review with a reasonable period. The state government shall extend all need-based assistance, my lord. It talks about need-based assistance in obtaining such clearances, including the licenses, approvals, sanction, permits, as may be required for the project. My lord, but primary, it is the duty of the petitioner to obtain the clearances. Why I'm showing this, my lord, till that no clearances. Then termination of agreement is page 82.
82.
12.1.
Yes, you have mentioned it.
Yes, my lord. The company shall achieve the financial closure within a period of 12 months from the date of receipt of techno-economical clearance, TEC from the Central Electricity Authority, approval from the Ministry of Environment and Forest, and other statutory clearances. In the event it is confirmed as impossible or impractical to achieve financial closure or if the financial closure is not achieved on or before the expiry of 12 months from the aforesaid date, for the reasons other than those attributed to the government of Arunachal Pradesh, the government of Arunachal Pradesh reserves the right to terminate the agreement. My lord.
Okay.
My lord, I'll not bother, my lord. The financial closure and financial agreement has been defined in page 73. My lord.
Now, where is now we will go to that termination clause. Now, where is the termination order?
Termination order, my lord, will find letter of termination is at
92, my
page
lord.
1.
Huh?
192, my lords.
192.
Yes. 192.
Yes, one. My lord, if I read, my lord.
Just a minute. 190. No, 193 is something different.
192. 192.
192.
Yes, ma'am. 192. Annexure 8.
It's something different, right?
One 192.
One 192. Just a minute.
It looks like 182. Handwritten and the pagination.
Annexure 8.
8.
Huh?
Yes.
Yes, ma'am.
This starts with 190, Annexure 8. In the court's copy.
Okay, ours is 192.
Yes.
My lord, may I read the termination, my lord?
No, this is
This
Department of Hydro letter of termination. Okay.
yes, letter of termination. This was issued on 27/4/2021. my lord.
What is letter dated 1/7/2020?
That was the intention for termination, my lord.
Where is that?
My lord will find that at
Page
94, my lords.
94.
Sorry, my lords, just a little above 94. That is at 91.
91.
Yes, my lord. And the reply is at 94.
91. Annexure 6.
This is the intention to terminate, my lord.
All paginations are not telling with you.
91, my lords.
March 17, DS Construction.
Yes. Annexure 6, my lord.
Annexure 6.
Yes, my lord. Annexure 6.
Page 89. 89. Yes.
This is the intention to terminate, my lord. Notice for
It
intention.
is dated.
It is, my lord, dated
5/3/2020, my lord.
5/3/2020.
5/3/2020.
If my lord comes to the intention to, we have narrated the facts. So post notices were issued. First so post notice at page 81. My lord.
Okay, then what is their reply?
My lord, their reply, my lord, they have tried to explain everything and they have stated that it is not their fault, but it is because of the non-cooperation of the government of AP and the lackadaisical the approach of the government, my lord. If my lord will come to page 190, I believe court's copy it will be 188. In fact, they have put the allegation on us. Why? The basic reason for termination is still that they have not obtained any clearance, statutory clearances required. The project was supposed to be implemented within a period of 4 years, madam, after obtaining the clearances.
What we are looking at is these facts because your basic ground is limitation. Okay. And as such, it is not barred by limitation so far relating to section 11 is still 11 comes. There is no doubt about that.
Yes, ma'am.
You are raising a dispute as regards limitation of the claim itself.
Yes, my lord.
Your
Yes, the
claim
course
itself.
of action.
Now, cause of action or claim,
Yes.
per se claim, there is no absolute bar as such upon a court exercising jurisdiction under section 11 subsection 6 to go into that aspect, but it should be crystal clear.
My lord, that's why.
That is the only point, but they are raising certain issues. Anyway, you proceed.
My lord,
Yes.
what in the reply to the intention to terminate, my lord, they have basically given that it is the government, state government who has not cooperated. It is their lackadaisical attitude, my lord. That's why these NOCs could not be obtained. Now, that is their claim. Now, because of this, they are making a claim, further claim of loss of profit and all earning, my lord. Now, this reason, my lord, for not obtaining the required NOCs, whether they can now raise it after the expiry of the statutory the time period
After completion of contract.
after because the project was to be commenced within a period of 4 years. Now they had to obtain within the period of 4 years, they had to obtain all the required NOCs and then start the this project.
So your case is that in terms of the contract, they are to start the project within certain dates.
Yes.
Isn't it?
Yes.
Within certain date and complete it within certain date.
Yes.
If there is any fault on our part, that cause of action will arise from that date.
Yes, my lord.
Therefore, at this stage, the claim itself is barred by limitation.
My lord, their basic ground is that you did not help us in obtaining. If they had this right that to claim that the government was duty bound to help them, what our stand is that?
No, understand.
Our stand is that it is their lookout.
That clause itself says it is your responsibility to obtain everything. So therefore, blaming at this stage
Yes.
cannot be a ground.
If they had
But again, I'm repeating.
Yes.
Again, these are mixed questions of facts and law.
My lord, that's why I'll just show one of the judgments because that.
Okay, so what's that judgment? Which
Yes.
judgment?
So whether my case will fall under this, my lord, I'll just.
Okay, just where
I'll try to bring it under this because it is a.
Which judgment? Tell us name of the parties.
BNP AG versus Union of India.
Okay.
Because now before the deadline, had they raised this issue, we could have understood. Now after the termination, they are
The recent judgment.
yes, very recent.
Very recent judgment.
Yes.
Where it says, this is the principle of what I am saying. where it says that it should be,
Cause of
there are
action,
two issues determined, paragraph 68, yes.
68, my lord. Cause of action, my lord. Their claim should be within that period, not after the termination, after abandoning the project. Okay. And then, because there is a subsequent.
Okay, we understand.
My lord, I'll just read more. I'm trying to emphasize, my lord, whether any particular facts constitute a cause of action has to be determined with reference to the facts of each case and with reference to the substance rather than the form of action. If an infringement of a right happens at a particular time, the whole course of action will be said to have arisen then and there. In such a case, it is not open to a party to sit tight and not to file an application for settlement of dispute of his right, which has been infringed. Infringed within the time provided by the Limitation Act and allow his right to be extinguished by lapse of time and thereafter to wait for another course of action of his right, course of action, and then file an application under Section 11 of the 1996 Act for establishment of his right, which was not then alive. I'm emphasizing because if they are claiming that it was your duty, if it to help us in obtaining this NOCs, then they should have raised it within the time frame given. Now they have totally abandoned the project, and now a new course of action, that is the termination, has come. Now they are raising it. That is what I'm saying. Therefore, my lord, there is, his claim is totally, there is no live issue. It is just to arm twist the government and go. So otherwise, from 2010, since 2006 was the MOU, the within 4 years, that is 2010, the
Where is his claim, demand of claim?
Yes, my lord. Demand of claim, my lord.
Page.
It will start, my lord. It's page 243. Otherwise, it will be, I think, in the court's copy 241. 2 pages.
MSA Partners?
Yes, my lord.
It starts at 239.
239. Also 243. And that will see the internal page 1, 2, 3, 4. There is a chart. If my lord has seen their box, in a box, they have made a chart.
Box
in after para 6, in para 16. Capital work in progress, fixed asset, EPC expenses, interest at the rate of so and so from year so and so to so and so, loss of account of loss of return, loss of on account of deprivation of revenue for generation over and above design energy and on account of cancellation of allotment of Yang HEP, loss of opportunity, loss on account of loss of opportunity to earn additional revenue through a sale of revenue energy certificate, claim for loss of opportunity, additional earning through percentage sale of power. These are, and my lord, what I'll just take my lord. Their claim are basically that the state government has not helped them in obtaining the license. And then in their reply also, my lord, before reply to the intention of termination. My lord, my page is in the last page of the reply. It is mine is 191. Court's copy will be 187. If my lord has My lord, if last second page of their reply. The state government's attitude has been the cause of
Pace.
in our in the
Tell us your pace.
190.
190.
Yes.
It starts with letter of termination. Which clause? Here page 190 is Annexure 8, letter of termination.
Termination. My lord, then 2 page prior to that.
Prior to that, yes.
The state government's attitude has, my lord, if my lord will see, the
Where?
2 page prior to this.
Starts with
Second para, the state's government attitude. The state government's attitude has been the cause of delay, not as has been allegedly any action on the part of the NDPL. The government's failure to act in a timely manner, its inordinate delay in the revalidation of the THC, and its failure to enable and provide essential cooperation for clearances, specifically the environment clearance and forest clearance to be accorded by so-and-so, and clearance from Ministry of Tribal Affairs, Government of India, is the reason for the long delay that has occurred. As such, no reason for delay to commence the work can be attributed to. So this is the, and then further, my lord, in the last, what they are saying. The second para of the last, NDPL remains committed to perform its obligation under the MOA and for the development of the project. However, my lord, it says, it is also reiterated and bears emphasis that no progress in the project will be possible in spite of the highest efforts made by the NDPL without the government performing its reciprocal obligations and performing its sovereign functions towards the enabling the project. My lord, here NOCs, it was completely for the petitioners to be to obtain it. This government was required to help them, but now they are saying they are putting the burden on the government, and they are saying that we cannot proceed. Now, this claim they should have raised if they had any right under the MOU that they can seek for this, they can ask this claim. Then they should have raised it.
So according to you, the dispute raised, this cause of action arose way back after in fact expiry of 1 year when they could not.
Yes.
And therefore, our termination cannot be a cause of action for the claim, that may be cause of action for section 11.
Yes.
And in support of this, you rely on this
Yes, my
judgment
lord.
where
Because
both the issues, what should be two issues were framed, second part is relevant for you.
Yes, ma'am.
Second issue is relevant for you. Yes. That's
So,
all?
yes, ma'am.
Yes.
May it please your lordships. My lords, the
Yes.
judgment, my lords, the judgment referred to by my learned friend, my lords, is in the context of the breaking point in conciliation or negotiation proceedings, my lords. Here, the judgment in my respectful submission has no application, my lords. There was an intention to terminate notice given to me. I will show your lordships the date. I replied to it. Thereafter, they terminated the contract and I replied to it, referring the matter to arbitration, my lords. Now, my cause of action till the contract was alive does not arise. It is only upon the termination of the contract does the cause of action arise in my favor, my lords. Now, as to before that, whether I was able to execute the work, whether my claim was alive or dead, or whether I was idling at the project site, whether it was my responsibility to obtain permissions from or NOC from the statutory authorities, whether the state government had to help me or not. Well, these are all questions of fact, which has to be, in my respectful submission, seen by an arbitral tribunal, my lords. Before your lordships, my lords, I would only submit one judgment for your lordships' kind consideration. It's a full bench of the Honorable Supreme Court in Vidyadhrolia.
In fact, Vidyadhrolia is dealt in this judgment.
Yes, my lords. But just kindly see para 148 for a second. If my learned friend before
Vidyadhrolia.
Yes, my
Okay,
lords.
ready?
You can hand over a copy, my lords.
Vidyadhrolia, in fact, what should be the jurisdiction of code under section 11
Yes,
has
my
been
lord.
elaborately dealt.
Yes, my
How,
lord. Just
how
one
is to be,
paragraph. Just one paragraph. I won't trouble your lordships further.
will give the book. Yes, are you assisting?
Yes,
You
my
are
lord.
without the book. You are getting a chance to do all this and you are sitting here to show your faces. Yes.
My lord, just paragraph 148. My lord.
Citation was with the
Yes, my lord. Citation is 2021 2 SCC, page 1. 2021, volume 2 SCC, page 1.
Okay.
Paragraph 148, my lords. I'll just quickly read it out, my lords, for your lordships.
Paragraph 148.
Yes, only 148, my lords. Nothing
Yes.
further to refer, my lords. Section 43(1) of the Arbitration Act states that the Limitation Act 1963 shall apply to arbitrations as it applies to court proceedings. Subsection 2 states that the purposes of the Arbitration Act and Limitation Act, arbitration shall be deemed to have commenced on the date referred to in section 21. I have referred it to arbitration within 2 years of the termination, my lord. Limitation law is procedural, and normally disputes being factual would be for the arbitrator to decide, guided by the facts found and the law applicable. The court at the referral stage can interfere only when it is manifest that the claims are ex facie time barred and dead and there is no subsisting dispute.
In fact, in BNT SG,
Yes.
same principle has
Yes,
been
they
reiterated.
follow with their rule here. Yes, my lord is right.
Penultimate paragraph, the same thing is
Yes, my lords.
reiterated. And in
Therefore-
fact, this is a reproduction of the
Yes, ma'am.
principle of law in Vidyathulya.
Yes, my lord. I'm so grateful, my lords.
Yes.
Now, my lords, just two or three quick dates, my lords, for your lordship's kind consideration. The MOM was dated 22/6/06.
Yes.
The intention to terminate is dated 5/3/2020. 5/3/2020. The termination is 27/4/21. Petitioner invokes arbitration on 1/6/23 within the period of 2 years, my lords.
That's section 21.
Yes, my lord. Section 21 is triggered on 1/6/23. So therefore, my lords, it is my respectful submission that the matter has been referred to adjudication within the meaning of section 21, within the period of limitation, within the period of 3 years, my lord. And it is my respectful submission that considering the value of the dispute and among other and the complexity of the matter, we had proposed a tripartite tribunal and appointed the Honorable Mr. Justice A.K. Sikri, my lords. They have till date failed to do so despite the period of 30 days having expired for them to nominate their nominee arbitrator. The parties are ad idem, my lords, that it should go before a tripartite tribunal. We would kindly request your lordships to appoint a nominee arbitrator on behalf of the respondent, my lords. That is our limited prayer, my lords. The two, we would request your lordship to consider somebody from the Honorable High Court of Guwahati High Court, my lords, because the site of the venue for the arbitration is Guwahati as well, my lords. That is the only issue, my lords. And we kindly request your lordships to appoint.
Yes. So we'll dictate the order, we'll make it CAV. We'll deliver.
Grateful. I'm so grateful.
Not only that course of action. That's
No, understand.
and without prejudice to our rights, my lord. In the event, my lord, this arbitration letter should be appointed. We are also agreeable for three-member tribunal, my lord, and we will go by our affidavit, the suggested members, my lord, from Supreme Court.
You are moneyed state.
Your
Otherwise,
lordship will
course
kindly
of
appoint
action, my
somebody
lord,
from the Honorable High. The list, my lords, there's a notification dated 21st May 24, my lords. Since the venue is Guwahati, lordship may kindly appoint an honorable retired judge of the Honorable High Court of Guwahati, my lords. Because only the cost would also come down as that is.
Yes, so that is what we are suggesting.
Grateful.
Only
Great.
my lord will see whether their ground and the course of
No,
action.
that will elaborately deal
Yes,
with.
madam.
See, law is well settled. Vidya Julia, in fact, it should be crystal clear. And generally, limitation is a question, a mixed question of fact and law.
Yes, madam.
When specifically somebody raises some issues, we'll have to give a conclusion that no, there should be some, and in this case, more particularly, the contract was existed till suppose intention of no termination. You said that we want to intend termination in the year 2023.
My lord, in another judgment, my lord, Arif Azim Company Limited versus Aptech Limited, my lord, the Honorable Apex Court has also observed that the limitation of 3 years is also too long a period. My lord.
No, that is in fact, if you go through your judgment, this judgment,
Yes.
here also that observation is made. But legislature has not done it. We cannot. These are only wishes of the courts. It's not a dicta.
My
Here
lord,
also
see
it
the
has been
facts,
written.
my lord, in this
In this
case.
judgment, it is somewhere it is there.
Yes, my lord. The
That-
facts also, my lord, will see it because the claim was extinguished long time back, my lord. The claim should have been raised long time back. In the chart by the ASG. Otherwise, the very ground. For,
My lord,
we'll see.
my learned friend is at liberty to raise any ground under section 16, my lord. He can raise all these grounds under 16 before the honorable tribunal. Grateful, my lords.
Yes.
Obliged, my lord.
Hearing concluded. Judgment reserved.
Obliged.
Your Honor, we seem to have run into a bit of a problem. We seem to have run into a bit of problem. We have misplaced the file. Thereafter, we have painstakingly applied for the documents. That's why there's a delay.
So in some time.
Yeah, we would request some more time.
The learned counsel for the petitioner submits that for want of some vital document, the rejoinder affidavit could not be filed. Accordingly, he prays for an adjournment. Because the prayer is allowed, release this after 3 weeks.
Much obliged, John.
May I please, Your Lordship?
Yes, what is this?
This is regarding cancellation of my allotment for running of a tourist lodge. The government and deputy commissioner and the department have filed affidavits. There is nothing
Who is
that
respondent number 5?
respondent number 5 is the person to whom that tourist lodge has been
You are
allotted
for?
again.
I am for respondent number 1, 2, and 3.
And you are for? 4. Where is the order impugn?
The order impugn is, Lordship, at page 29.
Page 29.
30 August 22. The respondent number 5's name is at serial number 1. What happened is, Lordship,
So it was leased to respondent number 5.
no, it was leased to me earlier. I had paid the
where is
security
your
deposit
lease?
also. The lease is at approval is at page 24. Actually, this is not an approval. This is a communication of the approval. 14 July 2022. According to this, I was supposed to deposit some amount, which I did. That is on the next page.
Now, this should, by way of this, you have been granted to run the tourist lodge.
Yes.
In whose premises?
No, it is at Pasigat.
The building belongs to the state.
Yes, but since it was in a very
Very bad condition.
bad
you'll have-
conditions.
you'll have to renovate and run it for
Yeah,
25
the
years.
state was of the opinion that because it is in such a dilapidated condition,
Okay, that is
it
clear.
would, yes, it
The
won't
state
be,
has said, renovate, revive the tourist lot at Gulnagar, Pasigat
yes.
on from their own expenses.
The
state
deputy
is-
commissioner had written to the director tourism saying that there we may not find any interested bidder because the building is in such a bad condition.
Now what happened thereafter?
Thereafter I was approval was given for,
Is there any stay?
yes.
You are running now?
No.
Why?
We're not running because even after, because there has to be a deed of agreement that was not signed. There was not signed. So thereafter,
Now it is given to angling club and tourist view.
no, to the
Tourist lodge to
respondent, in the serial number 1, tourist lodge at Gumin Nagar, Miriam Komot.
what is the reason of this?
In the affidavits, there is nothing.
I have no idea about this.
You are representing whom?
And
Who is representing deputy commissioner? What is the reason?
My lordship, in our affidavit, we have said that,
Para 6 affidavit.
para 6, my lordship.
Para
That with regard to statement made in para 4 of the writ petition, the answering respondent begs to state that the application dated 15/9/2022 was submitted by the petitioner for the draw of lease agreement and handing over the tourist lodge. That the lease agreement could not draw as another lease approval was received from the Director of Tourism.
Who is director of tourism? What is your stand?
Lordship, the standing council is out of station due to some personal difficulties.
In fact, lordship, the case
Who
was
is
filed in the
standing
year
counsel?
And Pada.
We are taking up it on Monday. Come with the record. Okay. Hard
Lordship, 1 week may be given.
MSN Rangan, learned counsel for the petitioner. The present application is filed assailing an order dated 30th of August 2022.
Yes.
30th of August 2022, whereby the tourist laws at Gumi Nagar.
Gumin.
Huh?
And Gumin.
Gumi
Nagar.
Gumi Nagar.
Actually, it's wrong here. It's Gumin Nagar.
Okay, is you'll know. Okay. Gumi Nagar was allotted to respondent number
5.
In supersession of an earlier communication dated 14th of July 2022, whereby lease was granted.
Approval for lease.
Approval for lease was granted in favor of the petitioner. Full stop. None appears for the respondent number 5 on call. Full stop. The deputy commissioner had filed an affidavit taking a stand that deputy commissioner has filed an affidavit. Full stop. From the stand of the deputy commissioner, it is seen that the said deputy commissioner has not disputed issuance of communication dated 14th of July 2022. However, it is his stand that due to another approval granted by Director of Tourism, such lease granted was cancelled. Full stop. The learned counsel, Mr. Swenso, learned counsel appearing on behalf of
And Pada.
learned standing counsel for the tourism department, seeks for an adjournment. Full stop. On the ground, seeks for an adjournment on the ground that Mr. Pada is having some personal difficulty today. Prayer is allowed. However, since the matter involves an important public asset, that is a tourist lodge at Gumi Nagar, and 2 lease approval has been granted, this court would like to peruse the record of the director, and on the next date fixed, it is also to be clarified who is the authority to grant lease in respect of the said tourist lodge. Please this matter on Monday.
Obliged.
Yes, my lord, notice is issues to the respondent number 7 and respondent number 9. And respondent 7 has filed their affidavit, and respondent number 9, press have also been has already been taken.
But
Respondent number 9.
anybody for 9?
Yes, my lord.
7 and 9. 7 file affidavit.
I have just been appointed as the counsel.
Okay. Though office note dated 5/8/2024 reflects that service in respect of respondent number 9 is still awaited. However, the Mr.
A Gamre.
A.
Gamre.
Gamle, learned counsel, has entered appearance on behalf of the respondent number 9 and seeks for an adjournment to enable him to file affidavit.
And also
in
to file
opposition.
wakalat number. And we
We file it accordingly. Matter stands adjourned and be listed after 4 weeks. In the meantime, the learned counsel may file his wakalatnama as well as the affidavit.
My lordship.
Who is the respondent number 7?
Lordship, private respondent.
When steps was taken? Take first steps. In view of the office note dated 5/8/2024, learned counsel for the petitioner pressed for and is granted 10 days time to take fresh steps for issuance of notice upon respondent number 8. Full stop. In the meantime, the reply affidavit may be filed by the petitioner. List after 4 weeks.
Obliged.
Yes, Deuri.
Yeah, some repetition and challenging termination. Suspension order. No review was done till dates. It's more than 3 years.
Yes,
My lord, admittedly, my lord, no review done.
I had passed some judgments. This is CCS rules.
Yes, my lord.
Give us the copy of the judgment. Will not dictate disorders. I have passed as a Mr. Dicky was there.
I will provide tomorrow.
Give it to her.
Yes.
She will write a judgment. Just write it down. The case of the petitioner is that the petitioner was suspended by an order dated 8/12/2021. Full stop. 8/12/2021, and he or she has been under suspension since then. Full stop. According to the petitioner, no review has been exercised in terms of extent notification as well as in terms of the judgment rendered by Honorable Apex Court in the case of Ajay
Kumar Chaudhary.
Ajay Kumar Chaudhary versus
Union of India.
Union of India, reported in
2015.
Volume 7.
7 SCC 291.
291. Full stop. Mr. Kamduk, learned standing counsel for the department.
Yes, madam.
In
Education.
his usual fairness, submits on instruction that no exercise of review has been taken up for extension of the suspension till date. Full stop. In view of such candidate candidate admission, considering the notification dated, Mr. Paging, give the notification. In view of the aforesaid, the repetition stands allowed by setting aside the order of suspension. Full stop. give the last part. However, they will be at liberty to post him all and we continue the departmental process. Just if you take type this, I will see tomorrow. Let him give the order. Deeply organized. Dispose of. This is item number
26.
Notice has been received by respondent number 1 to 5, 1 to 4.
That we know, but we don't know thereafter. You have not done your responsibility. Steps for service upon the respondents not yet taken. In view of the office note dated 5/8/2024, learned counsel for the petitioner submits that 5 days time may be granted to him to take steps up for issuance of notice upon the respondents. Prayer is allowed, least after 4 weeks.
Obliged.
Deeply obliged.
Your Honor, we have received the affidavit filed by respondent number 3. So matter may be listed for hearing. If necessary, we'll file the affidavit in reply.
Your Lordship, a short date may be given, Your Lordship. Probably after a week, Your Lordship.
Second. Who is respondent number 3?
I am Your Lordship.
Who are you?
Your Lordship, I am the inquiry officer, Your Lordship.
There is no interim.
There is interim, Your
There is
Lordship,
interim, Your Honor.
which is why Your Lordship.
Where is the interim order?
Order dated, Your Lordship, 24/7, Your Lordship.
Huh?
24/7, Your Lordship.
24/7.
24, Your Lordship.
Your Honor, interim may be continued, Your Honor.
You have retired.
Yes, Your Honor.
When the notice was issued?
Notice was issued.
When the departmental proceeding was initiated?
What?
You are suspended for what? They have rightly initiated. Why should we stall this process?
Yes, Your Lordship.
Your Honor, the CCS rules dictates that the report has to be submitted within 6 months and at max 1 year. That there's also Supreme Court.
No, Supreme Court judgment we understand. What the service law prescribes. In certain cases, after retirement, there cannot be any departmental proceeding beyond 3 years, beyond 5 years from the cause of action. But here, when notice was issued?
Notice was issued on.
Yes, what do you propose?
Notice
Will not
was-
admit this matter today. Will it list it for admission? File your affidavit.
We have already filed, Your
You have
Lordship.
already filed.
Yes,
What is
Your-
your stand?
Your Lordship, today I'm not.
And who need to file that? Yes, you are also not ready.
Yes, Your Lordship.
As agreed to by the learned counsel for the parties, please this matter after 2 weeks.
Your Lordship, next week maybe, Your Lordship.
2 weeks. How many matters will fix in the next week?
Done. Interim may be
Next time
continued.
we'll be here for 2 months. Mr. Fanging, we are thinking of completing the election petition, staying here for 6 months. This after 2 weeks.
Meanwhile, interim may be continued, Your Honor.
Give a date, give a date. List this matter on 30th of August.
30. 30. Oh, 1.
1 3, no, don't give 1 3. Thereafter, after 19th. We'll fix it unnecessary. Nobody will file affidavit on 28th. Interim order, pass earlier shall continue till then.
Much obliged.
Yes.
Lordship, here issue is very simple, my lord. And the limited period.
What is limited period?
My lord, main period is, my lord, since the petitioner before your lordship is serving as ALC, my lord, auxiliary load carrier man. And she was appointed in the year 2023, my lord. But my lord, the respondent number 4 and 5, who is junior,
You want a disposal of your consideration of a case for promotion.
my lord.
This is your limited
Yes, my
period.
lord.
You consider it. Any private respondent here?
My lord, private respondent number 4 and 5, my lord, without disturbing them, my lord.
Okay. Heard Mr. M. Kato, learned counsel for the petitioner. Swenso Tap MS Basar. Huh?
Basar, R. Basar.
R. Basar. Learned government advocate appearing for respondent number 1, 2, and 3, and Mr. A. Lauren for respondent number 4. The present petition under the present petition under Article 226 of the Constitution of India is filed essayly an order dated 7/3/2018. Essayly an advertisement dated 7/3/2018, issued in respect of filing 4 posts of lower division clerk within LDC in the office of the Deputy Commissioner, West Siang District. Alo, respondent number 3. Still it is West Siang District?
Yes, ma'am.
Respondent number 3. With a further prayer to direct the respondent authorities to consider the case of the petitioner for promotion to the post of typist, to the post of LDC clerk from the post of typist, which the petitioner is holding as at present. In the holding as at present. Full stop. According to Mr. Kato, learned counsel for the petitioner, that similarly situated persons have already been regularized in their post as LDC in resultant vacancies, and therefore the case of the petitioner may also be considered by the respondent authorities, inasmuch as the petitioner had already filed representations before the authorities. Full stop. Mr. Kato further contends that he will not press his challenge to the advertisement dated 7/3/2018, inasmuch as pursuant to the such selection, the respondent number 4 had already been appointed to the post.
Not pursuant to that advertisement, Your Lordship.
No.
No, Lordship.
Advertisement is nothing.
They have not conducted the interview, Your Lordship. APSSB has conducted, Your Lordship, the interview.
Okay.
DC has cancelled the advertisement.
Now, what happened to the advertisement?
They have cancelled it, Your Lordship.
Okay.
DC,
Okay, don't write it. Let's full stop. Full stop. Now, he is not challenging the appointment of the respondent number 4. Stop there.
4 and 5. 4 and 5.
For appointment.
4
Now,
and 5, madam.
at this stage, the Learned State Council, MS Basar, submits that such advertisement was not acted upon,
yes.
and therefore no live cause of action so far the challenge to the advertisement is concerned.
APSSB has conducted the.
Yes, is there
Yes.
for the present repetition.
Lordship.
Full stop. That's all. However, she submits that if a representation is filed, the employer shall definitely consider the same, however, as per law and extant norms. Full stop. In view of the aforesaid consensus, the present writ petition stands disposed of, permitting the writ petitioner to file a fresh representation before her employer, namely
Deputy Commissioner,
Deputy Commissioner,
respondent number 3, madam.
West Siang District, that is respondent number 3. Full stop. Such representation, on receipt of such representation, comma, the Deputy Commissioner shall consider the same and pass a reasoned order in this regard. Full stop. Regard in as per extant norm and procedure laid down. Full stop. Such exercise be carried out within a period of 6 weeks from date of receipt of a representation along with a certified copy of the order passed today. Full stop. While parting with this record, it is made clear that this court has not commented on the merit of the claim of regularization of the petitioner as LDC, nor on the stand of the respondent state. Full stop. The Deputy Commissioner is to apply its own mind while considering the case of the petitioner as per extant norms. Full stop. With the aforesaid, writ petition stands disposed of.
Of like.
Deep level.
No cross examination.
No cross examination. That is the only ground. Record itself reveals, but the inquiry report reveals no. In fact, there were
Now,
other.
which is the rule applicable here? CCS conduct rules.
No, there's a police rules.
Police rules.
Yes.
Okay. What is the procedure under police rule?
But I'm sorry, but I have not annexed it.
No, not about. We can have the book. See,
I have not brought it also. I'm sorry, extremely sorry.
because see, basically, we'll see what is. I want to understand what is the procedure
Yes.
for a departmental proceeding. If that is not followed, then if it is resulted in prejudice, of course, we'll interfere.
My
If
lordship, we have the reports, my lordship.
So records is fine,
I can.
but we want to know the
Yes.
procedure
Yeah,
first.
yeah.
Then we'll go to the record.
Procedure was followed, my lordship.
No, procedure prescribed where? Procedure prescribed where? These are the fundamentals. Procedure may be prescribed in a statute. Procedure may be prescribed in a regulation. Procedure may be prescribed in an executive instruction. Then you will have to say that this is the procedure. There may not be the word cross examination.
Yes,
But there will be a procedure that there will be.
that is
there will be
there.
a reply. There
I'm
will be
sorry,
a-
madam, I did not bring it, but that is there in the police.
We'll
rules.
take it up any day. It will, because issue is very
Yes,
simple.
yes.
Any day next week or
Right. Right.
any day
I'll
next
bring the
week,
rules.
Tuesday.
Right.
As agreed to by the learned counsel for the parties, please this matter on Tuesday.
Right. Okay.
You have that. What
Yes,
is the
I will
policy?
bring it.
Because
Yes,
in-
yes,
if it would have been in Assam, I
Well.
would not have. Rule 9, Rule 7,
Yes.
I could have, but here I am not.
Yes.
So.
I will bring.
Matter over.